you say that, Counselor? Up until this decision, all prior Arizona's cases applying Rule 32.1G asked whether there had been a significant change in Arizona law. And Mr. Cattell is right that it was precedent overruled. And we even had it in a federal case, state versus, this is an Arizona case, state versus, I'm pronouncing it wrong, Poblete, P-O-B-L-E-T-E. Federal law, well, how do you say it?
Poblete.
Poblete, okay. I should have said it in Spanish to start with. It is poblete.
I had it wrong too, Your Honor.
That's what happens when I try to Americanize phrases. Poblete. Federal law changed Arizona's view, okay? It's changed Arizona's law on the Padilla question. And there, Arizona applied 32.1G. Here, however, Arizona says, nah, it asks whether there's been a significant change in Supreme Court law, not on Arizona press law. How's that not a novel interpretation? It's not a different context, it's a different test altogether. Yes. So when you're applying a new test, you're missing all the issues of why novelty is important, because we want to give people fair notice, right? And how could anyone have imagined the hair splitting that Arizona went through right now? All it has said in the past is, if our precedents have been overturned, that's 32.G.
Well, Your Honor.
1G, I mean, but.
Sorry, what did Ms.
Yeah. I guess the bottom line is, how is that not merely something radically different? It's a new test, it's not a new context.
Your Honor, I just respectfully disagree. I mean,
I know you disagree, but explain it to me.
Yes. Again, we see that test as simply a restatement or an extension of the test that the Arizona Supreme Court long ago said was how the court was going to approach interpretation.
Show me one Arizona case before this one where either the Supreme Court of the United States or the Supreme Court of Arizona had overruled a precedent and it had not applied 32.1G.
I can't point you to that, Your Honor. All I can is echo the point made by Justice Gorsuch that in this court's decision in Beard and subsequently in Walker that at some level you've got to give the Arizona Supreme Court a chance to flesh out its own rule, and that's what it was doing. This was a very unique situation. You know,
but it's the only unique situation where for 7 cases it refused to apply our precedent, where today there is an amicus brief by the Arizona Capital Representation Project that says that it's even refusing to apply Lynch today. It's finding every reason not to apply Lynch.
Yep.
At a certain point, don't we say stop?
But, well, Your Honor, I disagree with that characterization. That the Arizona Supreme Court has absolutely applied Lynch, and we cite to all the cases where they have. And remember, there's factual issues that underlie the Simmons claim. There has to be a showing of future dangerousness, and so there's issues that have to be vetted in these cases. It's not simply just you get a new resentencing as a result of the Lynch case. So every case has to stand on its own facts and is going to apply differently.